Thank you. You may be seated. Advocate Hassan.
Thank you, Justice.
I just want to quickly say this. I see a big headline on social media that claimants have been awarded 200,000 rand. No amount has been awarded at all. It is just so misleading, particularly to all those quick readers who look at headlines. Only the arbitrator can award an amount. All that happened this morning was the state indicating what amounts are they prepared to admit, not the amount that the arbitrator would lay down. It's an obvious error, but in this world of social media and fast headlines, it's totally unhelpful. So to journalists, just please go carefully. These are deliberations, and the final amount would come out at the end of the award. Counsel?
Thank you, Justice. We left off at the point of the litigation in December 2015,
Yes.
Which was preceded by a letter on 9 December 2015 by the lawyers for the parties, Section 27, representing SADAG, SASOP, the South African Federation of Mental Health, and the Association of Concerned Family Members of Residents of Life, Esidimeni. That letter was addressed to former MEC Mahlangu, Dr. Salabano, and Dr. Manamela. In it, Section 27 raised its clients' concerns regarding the need to assess mental health care users, the preparedness of public health facilities and NGOs to which the mental health care users would be transferred, and the potential violation of the user's right to health care services. They proposed a way forward that included a joint approach to court by the parties for the appointment of curators ad litem and for the suspension of all discharges pending the submission of reports from the curators. Dr. Manamela said that she did not respond to the letter as it was addressed to the former MEC Mahlangu and to Dr. Salabano. The litigation was in fact opposed by all of the parties, and including the Premier. The Premier testified that he was not aware of the litigation and that he gave no instruction to the attorneys to file a notice of intention to oppose. We ended in a position where the Premier's testimony was to the effect that matters arrive in his office and that it's handled by his officials, and that this litigation was never brought to his notice for an instruction as to the way forward. The end result being that a notice was filed without mandate from the political principal in that matter. The parties settled the litigation the day before the hearing. And the settlement was important because it provided for a consultative process with the families, and specifically that the department would not transfer mental health care users to new facilities unless they would receive health and other services of no lesser quality to those services that they were already receiving at Life Esidimeni. It's common cause now that the government parties did not honor the settlement agreement. In March 2016, the civil society organizations discovered that the department intended to move 54 mental health care users to Takalani Home, a facility that the department had classified as a facility for children with severe or profound intellectual disabilities. None of the 54 mental health care users was a child. They all had a variety of mental illnesses, including dementia, behavioral problems, hypersexuality, schizophrenia, and severe cognitive impairment. After an attempt to get an assurance from the department that the move would not go ahead, the civil society organizations made an urgent application to court to prevent the discharge of the mental health care users. It was brought in the form of an interim interdict. The department defended the litigation, and based on the misrepresentations by the officials, particularly Dr. Celebano, the court dismissed the application. And so began the mass dispersal of the patients to facilities scattered across the province.
Again, the question must pop up. Why all this subterfuge in order to achieve an unlawful end, i.e. to move these vulnerable patients? I mean, why? What we know now were lies in the affidavits. The question keeps popping up. Why was it so imperative to the extent of public officials lying in their affidavits? It continues to boggle the mind.
Just as it appeared that the department was more intent on opposing and fighting and warring with civil society in that litigation than addressing the real concerns that were being put on the table. And they were successful in their fight.
By untruthful depositions.
That is so. Ms. Mhlangu testified she did not remember whether she called a meeting to discuss defending that litigation, the March 2016 litigation. She also could not remember whether she opposed the interdict. She couldn't remember how many patients died at Takalani. She couldn't remember whether there was a typhoid outbreak at Takalani. So her evidence was of no use to us in trying to understand why, to answer your question, Justice, they defended the litigation in the manner they did. Justice, I was remiss in our written submissions on this point in not referring the arbitration to Section 165(4) of the Constitution. And I would like to make that submission now, coming after the submissions on the litigation in 2015 and 2016. 165 sub 4 of the Constitution requires organs of state to assist, they must assist and protect the courts to ensure the independence, impartiality, dignity, accessibility, and effectiveness of the courts. The manner in which the 2015 and 2016 litigation was handled, both in terms of dishonoring the settlement agreement in the first case and in the misrepresentation, the lies that were put to the court in the second, show a flagrant violation of 165(4) of the Constitution in our submission.
Yes.
And that too, Justice, we will submit, is relevant to the remedy. So the Takalani litigation then opened the floodgates, and then began the mass removals of and the mass transfer of patients to NGOs. And as we set out in our written submissions, the number of patients to be transferred was in excess of 950. The resolutions from a meeting in the MEC's office on 8 April 2016 show that at least 950 mental health care users needed to be moved to NGOs within 3 weeks. None of those mental health care users had been assessed for discharge by doctors. The second element of those minutes was that they were to be moved to NGOs, then assessed, and then it would be determined whether they should be moved elsewhere. So apart from just the en masse move out of Life Esidimeni, many mental health care users were moved from one NGO to another. And contrary to the protestations of some officials that it was just that the implementation of this plan went awry, the minutes of that meeting of 8 April show that it was by design. Examples of the move from transfer from NGO to NGO include Charity Ratsoso, who was moved from Life Esidimeni to Cullinan, CCRC, and then to Anchor. Sizwe Tlatswayo was moved from Life Esidimeni to an NGO in Hammanskraal, then to CCRC, and then to Anchor House. Daphne Ndlovu testified that CCRC took 21 mental health care users from Precious Angels when it was closed down. The mental health care users came via Kalafong and Pretoria West hospitals. So Justice has to demonstrate the point of the constant move from one place to another in the light of the evidence that was provided by the experts of the need to ensure the stability and a coherence and a security of the mental health care users in the manner in which they're transferred. The transfer was also characterized by the failure to provide clinical records and medication, or to ensure that the clinical records and the medication accompanied the mental health care users at each point along the way from facility to facility.
But surely all of these smart people would have known that it was a no-no to have mass removals of patients, isn't it?
Well, there were health professionals who were involved. So if nothing else, they were experts in something. They were experts in dealing with patients, and the duty on them was higher.
And just shows the egregiousness of their conduct. How they were determined to act unlawfully and uncaringly. They would have known, they should have known, and they did know, should I find, despite their denials.
Justice, I will be coming to that a bit later as well, and
Sure.
we will be submitting that it is undeniable in our view that they knew. They knew because they were told. Apart from our submission that they ought to have known, people in their position, officials in their position, and especially the health professionals. They knew because they were told. They were told by experts. It cannot come to the aid of the officials that they did not know that a mass move of patients in these circumstances would not come to the end that it did. Justice Professor Makgoba corroborated the evidence on the clinical records and the medication, but it would seem that in the process of the transfers, things went missing. And in addition to that problem of the access to medication, we also learned through the testimony of Ms. Franks that many of the patients did not have IDs. And she testified that she did not have IDs for 30 mental health care users under her care. And this is important because as a result of that, she had difficulties accessing care at hospitals for those mental health care users who were sick and who needed more acute attention at a hospital rather than being kept at the NGO at Anchor. While support from a family is important to ensure that a mental health care user is able to settle into a new environment, many families testify to not being informed of the moves. Some were told that the moves would happen, but they were not informed when they did happen or where their relatives were being moved to. The testimony also showed that the NGOs were given more mental health care users at a time than they could handle. Dr. Salabano acknowledged the overloading and the overcrowding at the NGOs. The problems didn't end there, because what happened next was the manner in which the mental health care users were transported and the manner in which they were selected to go to several of the NGOs. The process in the evidence, the common refrain was that the process described as chaotic. Mental health care users were left unattended outside Life Esidimeni facilities, and multiple NGOs and vehicles collecting the mental health care users. A document submitted by former MEC Mahlangu shows that many of the NGOs in fact used their own transport. In at least one instance, an NGO arrived at Life Esidimeni to collect mental health care users in a bakkie. Dr. Mkachwa testified that he instructed that the bakkie be turned away. The picking of mental health care users was evidenced through the testimony of Dr. Mkachwa and others, but Dr. Mkachwa said that he complained about this. He complained to the department that it was unacceptable for NGOs to arrive at the facility and choose which mental health care users they wished to take.
Yeah, almost reminiscent of slavery. I'll have that one, not that one. That one looks fitter than that one.
In the case of Cullinan, the facility staff went to Esidimeni to collect 10 mental health care users. Ms. Daphne and Ndlovu testified when they arrived at the facility, they were met by a group of 26 mental health care users and were told to take them to Cullinan on the basis that they had arrived with a 27-seater bus. In other words, there was space for more than they had come to collect, and therefore they were loaded onto the bus. When it comes to the identification of the NGOs, there appears to have been no system at all to ensure that the NGOs were suitable. All the NGOs, all they knew was that the NGOs provided care services, social services. They were all invited to a meeting in September 2015. At the meeting, they were told that they could sign up if they were interested in taking care of the mental health care users who were going to be moved out of Life Esidimeni.
Did any of the witnesses ever take responsibility for the change of tag in plan? I haven't had, remind me, any one of them saying, oh yeah, I was part of the decision not to take them to institutions, but actually to NGOs. Who owned up on that, if any?
As I recall, Justice, officials like Ms. Hannah Jacobus testified that she was aware that patients were going to be transferred to NGOs. The former MEC said the plan was always to take them to facilities and a few to NGOs. Nobody explained the reason why the transfer suddenly became so urgent that required the mass discharge.
And why? I really mean, who would have decided to change the rump of the plan? The plan was to institutions and only a few to NGOs. And I'm trying to reel back. I don't remember somebody saying, I decided no longer institutions except a few. The mass of the mental health care users must go to NGOs. Who made that decision?
That is no one owned up to making such a decision. What we do know is that although the initial reason, although the initial plan, they say, was to transfer most to public health facilities, that changed quite early on. And it was obvious from the evidence of SADAG that it was going to change because there was no space within the public health facilities. But no one took on the responsibility for the decision to use these NGOs and to transfer to more NGOs than were originally planned. Professor Makgoba, in his testimony, expressed his view that there were two indications that the NGOs were, in his words, mysteriously selected. The first was that there was never any clear selection criteria. In fact, there seemed to be no requirements for premises, staff, qualifications, or experience. The second is that there were already other NGOs in the province that would have had the experience to look after these patients, but new ones were brought in instead. New NGOs were brought in instead. So the best that Professor Makgoba could offer was that this was just mysterious. And the mystery was not cleared through the evidence in these hearings. With regard to the assessment and licensing, it was only by the time that Ms. Hannah Jacobus testified that it was plain and clear by her admission that there was no assessment of the NGOs before they were licensed and before the mental health care users were sent there. There had been denials earlier on by officials until Ms. Jacobus took the stand. Apart from the questionable assessment before the licensing and the rapid deterioration of NGOs following assessment and licensing when it did ostensibly or then occur, there were problems, as we know, in the licensing process itself. They reflected incorrect addresses, incorrect mental health care user classifications. All were backdated to 1 April 2016, regardless of the date of actual signature. All licenses were issued by Dr. Manamela, despite her not having the legal authority to do so. And at least some, if not all, the licenses were reissued by Dr. Selebano following his interview with Professor Makgoba, and those too were backdated to 1 April 2016. Ms. Jacobus testified she was the person in charge of licensing. She claimed not to have known about this having occurred. Dr. Selebano admitted to having reissued the licenses. What is shocking is that amongst those licenses that he reissued was a license for Precious Angels, which he issued at a time when the NGO had already closed down. He also reissued a license for the NGO Ubuhle Benkosi. This was after the discussion between him and Professor Makgoba about this NGO, Ubuhle Benkosi, and patients having been transferred from Marabastad to Lanseria Airport and then somewhere else. Despite that knowledge, and the transcript is there on the record, that Dr. Selebano was aware of this, with that knowledge, he reissued a license for Ubuhle Benkosi. Then we get to the conditions at the NGOs.
But as a matter of credibility, I know you're going to get there ultimately, we surely have to make factual findings around all these claims of ignorance. I did not know, I did not see this, I did not hear this. I did not open up my inbox of my email. I did not read the letter sent to me. I did not know about the litigation. It was done in my stead without my permission. I did not hear. Do the probabilities permit my holding these to be credible responses as a matter of factual finding?
Just as my submission is that the probabilities are that they are not credible. And they're not credible when you look at the context of the number of denials of not knowing. When you look at the number of attempts that were made to bring the information to the knowledge of the officials. and some of the admissions. So the admission is that the documents were received, letters were received, but I don't remember whether I dealt with it or not, says Dr. Salabano, for example. Ms. Mahlangu testifies that, yes, she did receive the letters, but she entrusted officials to deal with it. And when you read them all together, it's a smoke screen. And it's this blanket denial on all of the officials to try to evade what was staring them in the face, and what is staring them in the face in these hearings, and the responsibility that they bear for having made decisions in full with the knowledge that there would be
what
problems.
is the impact of that on the hurt of the families? Impact on what equitable redress ought to be? You're seeking closure and you confronted, if I so find, a bunch of lies.
There's one other thing in relation to probability, is that all of those warnings were public. They were in the media, in print media and on TV. I just wanted to point that out. I will be making submissions on how these facts relate to the remedy. And indeed, our submission is that it goes to the egregiousness of the offence and therefore the quantum. The conditions of the NGOs, if I could just turn to that, Justice. And again, we are all familiar now through 43 days of testimony with probably way too much detail. So what I'd like to highlight is that the evidence that emerged in the hearing, it's undisputed, paints a ghastly picture of the conditions of the NGOs. What does this picture look like? Food was insufficient, number one. The food was insufficient, of poor quality, or had to be provided by family members. 2, NGOs had problems accessing correct medications for mental health care users. 3, there was significant understaffing, especially in relation to nursing staff and access to a medical doctor. 4, some NGOs had insufficient security. 5, some NGOs were overcrowded. In others, there was poor hygiene, with dirty facilities and unwashed patients. Many of the NGOs were cold, and there were insufficient clothes and blankets. And finally, there was abuse or suspected abuse that was reported at some NGOs. This is not the totality of the description of the conditions of the NGOs, but these are some of the descriptions that emerged from all the testimony in these hearings.
This testimony is not from experts. It's from family members, isn't it? Men who saw the conditions, who experienced them, and who testified on them.
Well, no, Justice. It wasn't only from the families, because there were audit reports a series of audit reports that were filed, belated audit reports, I may add, in which the conditions of the facilities were recorded by department officials. And those descriptions are shocking in themselves. Shama House, for example.
Yeah. So the argument that experts, witnesses had no facts on which to make inferences of abuse, of shock, of likely anxiety, of depression, and all that went on with beginning to understand what their family, their loved ones were going through will have to be investigated carefully, isn't it? The facts are there.
Justice, the facts are there. The facts are in the department's own documents.
And we shouldn't expect experts to themselves give evidence of the facts.
It's not the role of the experts. The experts are to provide an opinion based on the facts that are given to them.
And the facts can be inferred from family members, from reports of the department, and so on.
And the report of the Ombud.
Yes.
Just as that the conditions of the NGOs are expanded upon in our written submissions, and we make reference to examples including Takalani and the evidence of Miss Boitumelo Mangena and her brother who went to find his mother but didn't recognize her because she had lost so much of weight. Mrs. Pertla's evidence about her daughter, Deborah Pertla, who had been kept in solitary confinement in a storeroom. The Reverend's evidence in relation to his son Billy, who was so hungry that he, when eating a bag of chips, licked the packet clean. Mr. Mokhorani testified that when he visited his brother at Rebafeni, his brother had lost so much of weight that Mr. Mokhorani could not recognize him. Mrs. Collitz testified that when she visited her husband, Frederick, he couldn't eat. He was not receiving his medication. He had lesions on his face and heels. And although he was clearly ill, the staff refused to take him to hospital. He passed away while she was making a desperate plea to the NGO to take him to the hospital. All of these circumstances, we now know, led to the deaths of at least 144 mental health care users.
And a lot of these conditions were also relayed by NGO owners or managers, isn't it?
That is so. Some of the NGO managers testified and confirmed, and their reason, their explanation was that they had not received the subsidy that were promised by the department. And that explained, in their view, the conditions at the NGOs and the problem of not having sufficient food and blankets and clothing.
So there's no paucity of facts from which certain expert inferences can be made.
Certainly not, Justice. The first mental health care user to die, as early as 26 March 2016, was Deborah Pertla, who died at Takalani with brown paper and plastic in her stomach. Following Deborah, at least 143 more mental health care users died. When Ms. Mahlangu answered to the provincial legislature on 13 September 2016, she said that 36 deaths had occurred. We know now that by that point, 82 people had in fact died. In her testimony, Ms. Mahlangu claimed she was unaware of the deaths until she was provided with information from her department just before she had to answer to the provincial legislature. When it was put to her, when a letter of 1st September 2016 from Section 27, in which it was several deaths were recorded, and when that letter was put to her, she said that, again, she'd referred it to relevant officials to deal with. We have on the record the response from Ms. Mahlangu saying, I will revert. That was a response to Section 27. She never reverted, but also she can't claim not to have known, as she later did during the hearing, that she didn't know that people were beginning to die. The families, through all of this, testified, and it was a recurring theme, their desperate search for their relatives. And that's because they were not provided with details as to where their relatives were going to be transferred and when. After the moves, most families were not informed, and some spent months searching for their relatives. And again, Justice, the examples are set out in the written submissions of the amount of time it took to locate their relatives, and more shockingly, the delay in informing relatives that, informing the families that the mental health care user had died. In the case of Ntombifuthi Dladla, she searched for her brother in several NGOs for more than 4 months. She couldn't find him. She approached the department directly. She went to the Department of Health offices on 20 January 2017. The officials were unable to help her. Eventually, Ms. Dladla was informed only on 10 February 2017 that her brother had died on 24 July 2016. And that brings us to the deceased and the bodies and handling of their corpses. And what Professor Makhuba says, and I quote from his report, from his evidence rather, he says there was total disregard, I think, for human dignity and human respect in terms of the patients and even after death. Many patients, many relatives did not know where their loved ones were, and many, I think, are still somewhere looking for them. And not having received answers proactively, they had to dig. They had to go knock at the many doors, and I think that was traumatic and frustrating over time. In other words, the lack of dignity, the failure to accord dignity to the mental health care users when they were alive continued after their deaths. I referred to Ms. Ntombifuthi Dladla and the delay in informing her of the death of her brother. And we've also heard her brother was Joseph Gumede, that when she identified her brother, his body had decomposed and was riddled with worms to the point that he could not be clothed in order to bury him. We have conflicting testimony as to why and what happened on that. We have, on the one hand, the evidence by Mr. Rasitsoge, who managed the mortuary at Cullinan, where Joseph Gumede's body was kept. His evidence was there was absolutely nothing wrong with the temperature and the temperature control of the mortuary. There were minor issues. There was routine maintenance. We saw maintenance invoices and repair invoices in which it suggested the contrary, that in fact they were aware that there was a problem and that the mortuary was not keeping cold. But in contradiction of that evidence, Mr. Rasitsoge says, in fact, all was fine. And that when he dispatched Mr. Gumede's body to Mamelodi Hospital, there was no decomposition of the body. But then we have Mr. Buda, who testified from Mamelodi Hospital, and he is the mortuary manager at that hospital, in which he says that the body arrived in a state of decomposition and in fact had to be moved because of the smell. In addition to that, we have evidence of the bodies that were moved from Precious Angels to Cotello Funeral Parlor and Put You to Rest Funeral Parlor, which does not have its own storage for bodies, despite this being a requirement of licensing.
Well, in all of the horror and pain of the facts from the facts, these operators were not unimaginative about names. Precious angels.
Put you to rest.
Put you to rest. I mean,
Justice, the put you to rest funeral parlor, as we know, in fact, didn't have a restful premises for deceased. They didn't have storage facilities. Instead, the bodies were transferred to a mortuary in Salisville, which is a converted butchery. And we heard the testimony not only of Ms. Phumzile Motsekwa, who spoke about the trauma, who herself is from Atteridgeville. So when she was informed of the address of this mortuary, her first thought was, but that's a butchery. And testified to her experience of visiting this mortuary and having to look through bodies to identify her relative. But we also have the evidence of DG Precious Matsoso, the Director General in the National Department, who investigated the facility upon hearing of the testimony of Ms. Motsekwa and others. And they are in the process of investigating that. And they found that there were more mortuaries, in fact, that were involved in the scheme at the time. And that's contained in the evidence in a report that was provided by the National Department of Health. As it stands right now, all we know is that there are continuing investigations in relation to those funeral homes and mortuaries. Justice, the heads of argument go on to deal with cruel, inhuman, and degrading treatment and torture. I'd like to address that in the section dealing with the breaches of the claimant's rights. I just want to point out.
I'll be asking your learned colleague for the state about that secondary trauma of the way deceased bodies were dealt with. It was just incredible that, as though it were not enough for the patients to die, the families had to confront all of this. And quite long after the actual death had ensued. And given the normal reverence that human beings tend to give to deceased bodies, it must have surely caused massive trauma. I'm not a psychiatrist, I'm not a psychologist, but mere common sense, isn't it?
I submit with respect, Justice, it is mere common sense. And the other factor in this was the inability of the families to pay due regard to their cultural practices.
Yes.
And to perform rites in the way that is prescribed in their cultural practices, which in itself has, I would submit, again, common sense, a traumatic impact.
And in the heads rightly you refer to account of Mr. Van Rooyen about his sister's body reminding him of the smell of dog feces.
Yes. And he wasn't the only person to testify. He wasn't the only family member to testify in that manner, comparing the smell of his sister. Others have said that the treatment of their relatives was worse than the treatment of a township dog.
Yeah, that speaks to deep, deep dehumanization.
Indeed,
anyway.
so, Justice. And you know, we refer in the written submission to the evidence of Ms. Trotter. It was Ms. Trotter that spoke about the word torture. And when she was questioned on it, she said, yes, it is a strong term. And if I could just read from that evidence, she says, it is a strong term. I think once you've decided that a group of people is undesirable and you dehumanize them, then actually you are in the terrain of torture. So if you take a group of people who didn't know the move was coming up, weren't prepared for it, and they are moved in the backs of trucks, tied with sheets, without supervision, without ID documents, without wheelchairs, without medical files, this is no longer a human endeavor. That in itself is a torture. This was done inhumanely, and so now we are in the terrain of torture. And then that doesn't stop, because the patients are moved into these filthy, dangerous environments as if they are not people. And then you know, for example, the Reverend saying that they wouldn't give Billy water because he would pee in his pants. So then you've got the withholding, you know, however people were fed or weren't fed, whatever happened in terms of all of that. You've now got something that is a basic human right, which is water and food, has become complex. That's torture. When you torture people, that's what you do. You play around with food. You play around with water. You deprive them at a sensory level. You overcrowd them. And all of those features of actively torturing people are in this situation. And her evidence was backed up by Professor Dye, who characterized the conditions as inhumane, cruel, and degrading. Justice, I don't want to dwell too much on the SAPS and the other role players, the Mental Health Review Board. It's in our written submissions, but what I would like to say is the importance of these sections is that at every turn, at every edifice of the state to which the families addressed their pleas, they were not heard. And when it came to the police, there were reports of the deaths, there were reports of the mortuary, there were requests for inquests, and the evidence is set out in our written submissions as to the unresponsiveness of the SAPS in that regard. The evidence shows the unresponsiveness of the Mental Health Review Board and what the requirements were of the Mental Health Review Board in these circumstances.
And before you walk away from the police, I was also struck by the casual attitude of doctors who completed death notices. And some, as you pointed out to me, appeared to have practice numbers. And they signed MBCHB. But there's no careful care to give respect even in death. Many would just write the name, IDs, sometimes incorrectly, and very perfunctorily natural causes, and leave the rest of the form almost uncompleted.
Justice,
what do you attribute that to?
So, Justice, just to add that it was not just that the forms were left incomplete, but in many of those examples that were pointed out during the hearing, the place in which the professional is supposed to select natural causes or not was not selected. Yet, that was the document that served as the basis for the issuing of the burial, the notice of death, of the death certificate, rather.
And that casual, that lack of professional care and industry made it difficult to decide whether or not this is a case that, as the law requires, deserves a post-mortem and subsequently an inquest. So you have a very small number, just about less than a third of the deceased who had post-mortems, because when you look at the forms, it's all natural death, natural death, natural death. Why do you think the doctors should have behaved this way, if they were doctors?
Justice, I would prefer not to speculate.
Yeah, very well.
is, of course, of great concern, that is the state of the bureaucracy, that we cannot rely on a death certificate to be true reflection.
You see, the point is it extends that failure to be punctilious and careful and caring about recording a death notice speaks to the kind of regard you have for the deceased. It's another act of dehumanization, even in death.
Yes.
Because the law requires us to do certain things to protect all of us if we were to die. And if our deaths were not natural, or caused by natural causes, whatever caused as a result of natural causes, then the law seeks to protect us. A post-mortem, followed by an inquest, an attempt to try and find the reasons for the death. That's part of the big human project, to preserve and respect life. That's what that is about. It's not just forms and people, it's about, even in death, did you die by natural causes or did somebody cause your death? And if there is, there ought to be criminal responsibility. But we denied that here by, just struck me, so many forms that were not properly filled and therefore difficult to identify the actual cause of the deceased.
That's so, because they were buried. As a result of that, they were not post-mortems, and it's a betrayal. It's not just a betrayal of the deceased, it's a betrayal of the public confidence in our state to be able to function at that level, to ensure that that important information is correctly captured. And again, Justice, the reason all of this goes to what all of this means in the context of the remedy that is being sought here. I'd like to deal with the issue of collective responsibility.
Just before you walk away about the police, I'm speaking from memory, but I saw no submissions about what I ought to say, if anything, about the police and criminal responsibility, even if it's by way of recommendation.
Justice, in the section where we deal with the other equitable redress, we ask that the parties and the public are updated as to the outcome of criminal investigations in respect of the officials.
You see, there are many obvious crimes here, aren't there? Should I be bothering to draw attention to them?
Most certainly, Justice. We've also led that in evidence. We provided in the cross-examination of Major General Johnson. Some time was spent discussing the range of crimes that are implicated in these series of events.
Yeah. Well short of murder and culpable homicide, many other offenses have been committed.
Including perjury.
Indeed. Including falsification, including fraud, including uttering.
And all of those, as I recall at the end of the hearing, and Major General Johnson undertook to report back on the letter that was sent to the SAPS that went unresponded, the 24-page letter in which it was set out the various potential criminal acts that had been committed.
And did we get that letter as part of the record? It was handed in.
It is in the record, Justice.
Okay. If you could get your junior to get me the Ella number, it might make my task a little easier.
I'll get it for you in due course. It's actually in the record. It's not an Ella.
Yes. No, very well. You may proceed.
I can't turn away from the facts without addressing the issue of collective responsibility. the theme of collective responsibility that emerged in the evidence. There was this common refrain that the officials held a collective responsibility, and they were eager to eschew individual responsibility by relying on this theme of collective responsibility. Former MEC Mahlangu testified that a government decision is never an individual decision, and to say that it was hers, her decision, any of these decisions, would be misleading, she says. She explained, and I quote, "The decision to terminate the contract with Life Esidimeni was our collective decision as a department after submitted to the Treasury." The collective, she says, included her, Dr. Celebano, and everyone in the meeting. Ms. Mahlangu testified that government decisions are never individual decisions, irrespective of seniority. But she did seek to place the blame on the head of department when she was asked if there was one person who would be responsible. Dr. Celebano, for his part, portrayed the implementation of the plan as a collective plan that was presented to him and that he signed off on the advice of managers from legal, finance, and mental health. Dr. Celebano acknowledged that once approved, the head of department takes accountability for implementation, but said that it was very difficult for him to monitor this at an operational level. He maintained that while he was accountable for what happened in the department, he could not be considered responsible for the outcomes of the project. Dr. Manamela testified that her individual responsibility was to ensure, in her words, to ensure that things are running smooth, and that it was the responsibility of the NGOs to protect the patients. She maintained that she was not directly responsible for the termination of the contract, implementation, payment, visiting of NGOs, assessment of NGOs, service level agreements, or discharging mental health care users from Cullinan to NGOs. She emphasized that it was merely a collective endeavor. This constant reference to collective responsibility and a collective endeavor shows, in our submission, a willful disregard or an ignorance of their constitutional obligations. And it's a shocking indictment on the state of governments in the department that they continue to use that as a defense, and that the Constitution seems
as a matter of
anathema.
law, what is that? As a political concept, I suppose it's saying we're a collective and we want to act in tandem. In my younger revolutionary days, I used to talk about democratic centralism. It's the notion that you all own the decision once it has been taken. So it's a nice, fancy thing in political and uprising circles. But what is it in law?
There's no place in the law, Justice. And that's our submission on this. It's as if the Constitution and the statutes that governed them is an anathema. The law sets out specific individual responsibilities.
Yes, absolutely. It apportions public power. And once it's vested in you, you are the one who makes the decision. You can listen to the whole world, but thereafter, you make the decision.
Well, it is what they are paid to do.
That's what
And in
they're paid
senior
to do.
position, they're paid very well to do it.
So collective responsibility is what? It's nice political jargon. But in law, I don't know what it is. If you're a magistrate, either you have the power to marry somebody or you don't have the power. It has nothing to do with many other magistrates that might be around you or any other body else. So the law is quite careful to identify decision makers. And our whole administrative law is premised on the notion of decision making, a decision. And normally the person must have the power to make the decision. With no viras, no decision. So you can't in your life say, Mr. Musenochi, made the decision, can he? Does he have the power? It's the first question you must ask. So I thought you might know more about what collective responsibility
Well,
is
Justice,
in law.
our submission is that there's no such thing as collective responsibility in law, because if there was, then we'd have no accountability. We'd be shaken to our foundations if we aren't able to hold politicians accountable, officials, bureaucrats accountable. We can't rely, in any event, just through the election process and political process. That's a separate and a parallel part of our political life that has no place in the law. And the added, again, and the salt in the wound, is that the officials come here and say that there was collective responsibility, that they would not take individual responsibility, and that they didn't know. And which in itself is a further affront to the families. It's an insult. It's contemptuous.
Because the whole constitutional scheme, indeed you're right, the whole constitutional scheme is to understand who wields which power. We know who appoints judges, we know who appoints the cabinet, we know who appoints whatever, we know who issues licenses, we know who will give you a driver's license. These powers are clearly defined. They have nothing to do with the collective.
That is so.
Of course you may discuss with many, of course you may consult, of course you may talk to your wife or lover about it in the evening, but in the end you have to make the decision. And the law holds you to account, and that's the decision that the law sets aside. So I don't know what collective responsibility is, but we might hear more from your other colleagues.
It would be interesting to hear how we are to understand this, other than the only way in which I can say, which is that it's to be disregarded. It's a political term. It has no place in our law, and as I say, it's the shocking aspect is that the officials seem to think that it is a permissible answer, and without any cognizance of all of the obligations that they bear in statute and in the Constitution. Justice, that brings me to the next section, which is the breaches of claimants' rights, which is the next part of my submissions. And that's set out from page 61 of the heads of argument. And we submit that the claim for constitutional damages is founded on the severe breaches by the government of the constitutional rights of the claimants. And what is important to bear in mind is that the bereaved families were compelled to place their loved ones in the care of the state, in the hands of the government, because they did not have the skills and the resources to provide the care themselves. They relied on the public health system and the effectiveness of that system to provide care to their relatives.
The first requirement, of course, of contemplating constitutional damages is you must show a constitutional breach. I haven't had any of your colleagues argue that there were no constitutional breaches. Could we, on the facts, ever argue that?
I think it's been conceded, maybe not in the terms of the language that is used in the Constitution, but I would be very surprised to hear anyone argue that the breaches of the rights that we set out did not in fact take place. And I will in a moment also refer to the testimony of the officials who acknowledge the egregiousness of the violations.
Starting from Professor Makoba, who's a high-flying clinician and professor in medicine, he could readily identify the constitutional breaches in his report.
He did. We expect that, judging from the argument, the written argument by the state, that there'll be something more to be said about this. They deny breaches of rights in their heads of argument. They deny that constitutional damages are to be awarded. And they do that on the basis that there are no rights that have been violated. It's an astounding claim, and I'd like to address it in reply.
Well, I understood the argument a little differently. I thought they considered that there have been constitutional breaches. They set out the test. First, there must be constitutional breaches. Second, you must then formulate equitable redress in the face of the breach. And they say, well, you have to formulate it in common law terms because there are no constitutional damages available other than through the common law. I thought that was the...
Well, it's...
But of course...
That is part of the argument. But I'll in a reply address the point I'm making about the claim that there isn't a breach.
Okay.
But it is correct that part of the argument is that there's equitable redress that is achieved through common law damages. What we set out as far as the breaches go is when we begin with the right to dignity, and we do so deliberately, because at the center of this case is the right to dignity. The dignity of the mental health care users while they were alive, the dignity of mental health care users after they passed away, the dignity of the family members who watched their loved ones waste away and die, the dignity of the family members who were powerless to do anything to prevent it. We also begin with dignity because it holds a particular place and a particular importance in our law. In the case of NM, the late Justice Madala stated that while it is not suggested, and I'm quote, while it is not suggested that there is a hierarchy of rights, it cannot be gainsaid that dignity occupies a central position. After all, that was the whole aim of the struggle against apartheid, the restoration of human dignity, equality, and freedom. The concept of Ubuntu underlies our constitution as a whole. It's closely connected with the right to dignity. Justice Masaneke, you yourself highlighted the importance of the communal nature of society and, in your words, the ideas of humaneness, social justice, and fairness.
Well, Counsel Flattery won't give you more money for your clients.
Justice, rather, I'm saying you can't run away from your words. You spoke of group solidarity, compassion, respect, human dignity, conformity to basic norms, and collective unity. And you did so in the Everfresh case. Its presence in the Constitution was confirmed, of course, in the early jurisprudence of the Constitutional Court, in which the court held that a person's status as a human being entitled to unconditional respect, dignity, value, and acceptance from the members of the community such person happens to be a part of. It also entails a converse, that there's a corresponding duty to give the same respect, dignity, value, and acceptance. And of course, in De Koko, the court repeated the importance and the intrinsic nature of Ubuntu to our constitutional culture.
And the dignity protection, of course, is a bulwark against abuse by the vulnerable in society. Because what the law does is to give them that protection even if they have nothing. Even if they have nothing materially, or by standing, or high ranking, or any of all those things. But the starting point of our Constitution is you are human, and therefore you're dignified. Stop
and as you say, Justice, it's there specifically, the importance of it grows when it's the vulnerable, the disempowered, disabled.
Yes. So it's not just idle. It's important when you have nothing else and you're open to abuse, and the law seeks to protect you by at least recognizing the bare minimum. Naked or clothed in gold or in nothing, you would still be worth something, and that worth ought to be protected. So it's very opposite here, where people are totally vulnerable.
And whose dignity was violated in the most wanton and flagrant manner, in which the department would submit paid lip service to policies like Batho Pele. And what is the meaning of having those posters on the walls of government offices then? We submit, in other words, that the claimants were stripped of their dignity in the way that they were treated in this process. The right to cruel, inhuman, and degrading, the right not to be treated in cruel, inhuman, or degrading manner is also a self-standing right in the Constitution. It's closely related to the right to dignity. And as stated in Makwanyane, a denial of humanity amounts to cruel, inhuman, and degrading treatment. Here, ultimately, it resulted in a deprivation of life, as in Makwanyane, as in the considerations in Makwanyane. Thirdly, we referred to the right to family life. And we're quite aware that there's no express entrenchment of this right in the Constitution. But like cruel, inhuman, and degrading treatment, our argument is this is closely linked to the right to dignity. We rely on the Dawood case, in which the court stated the following: human beings are social beings whose humanity is expressed through their relationship with others. The family unit, in our submission, is an important source of security and comfort and support and companionship, and any action that violates the integrity of the family unit violates the right to dignity as well. We refer, Your Justice, in our heads of argument to the Gladla case in order to support this argument. And we'd like to add that one of the secondary trauma, if you may call it, that rested on the family was the perception or the accusation that they did not care about their relatives. The families continue to seek answers as to how and why the government excluded them from participating in decisions about their loved ones' care and why their loved ones lost their lives. We submit that the right to family life has been breached by the deprivation of the opportunity to take decisions in the best interests of their relatives. Not only did they lose their relatives in this tragedy, they lost their power to ensure that their needs would be met. The right to equality is implicated, particularly on the basis that these mental health care users suffered from a disability. We submit in our written submissions that what is evident is a violation of Section 9 of the Constitution in the manner in which mental health care users were treated and the discrimination against them as people with disability. In other words, discrimination on a listed ground. What is worse is that it was perpetuated against those who are unable to speak for themselves.
I struggled a bit with that argument. What would your comparator be?
Well,
they as a group together in one institution were treated horribly, and nobody was spared the horror. Some lived, survived in other words, and others did not. And in equality inquiry, you normally would go and look for a comparator.
Justice, we base our argument on...
You gave to girls more sweets than you gave to boys. Explain yourself.
Our argument is that the choice of this program and to cut this program, we've had no reasons that we can rely upon. The three that were provided are not doesn't come to the assistance of the government. There's no explanation. What we do know is that this group of people was chosen as a cost-cutting measure. What we also know is that there is stigma in relation to mentally ill people in our society, and we rely on the evidence of Professor Grobler in that regard. And what we say is that the indirect, it need not be direct discrimination, but the manner in which this was carried out, starting from the decision to terminate, there is nothing on the evidence to show why this group and this group of mental health care users, why this group of the population that relies on health services was selected. Why were they chosen and not cutting consultants' costs? Why did it happen?
Well, I'm talking about the normal legal inquiry on inequality, or I'm sorry, on discrimination.
On discrimination.
You have to, at the very least, find a comparator. But they would have been treated otherwise but for their disability. Because look, this set of disabled people were treated in another way. So you always have to, as a starting point, I don't say it's the only way to do it, but the jurisprudence has always been, you give soccer more money than rugby as a code, assuming the numbers are comparable. And then the question becomes, is that distinction, does that distinction rise to discrimination? If it does, is the discrimination unjustified? You know the inquiry. The inquiry has been there. It's
yes,
quite clear.
Hawks and yes.
Yes, indeed. So I'm struggling to find a comparator. And some of your colleagues might be able to. They are treated differently from an similarly placed other cohort or group. That's normally how discrimination works. Married people and unmarried people, and treat them differently, or boys and girls, or
Justice, the comparison here is between
Christians and traditionalist believers, or so you need comparators to be able to, for the inquiry to be meaningful.
I hear your point, Justice, and my response to that would be first that the comparison here is between types of healthcare users, and these being mental healthcare users, and the fact that all of the circumstances that we've described were only possible because they were mental healthcare users. They couldn't speak for themselves. And that in relation to in conjunction with our argument on stigma and with the particular position of this group of people in society, that's the basis upon which our submission rests. And perhaps
other argument could be had they been a collection of another category of healthcare users, they would have been better placed. They were discriminated against because they were known to be vulnerable and therefore easier to ill-treat. But one has always got to say, look at them. They've been treated better than them. But it doesn't detract from the rest. I mean, you know, dignity and cruelty and inhuman, all of those things, all, you know, right to life, and it's a whole collection of them which are together there. I just don't know, as a matter of law, equality finds jurisprudential place. I've got a hunch there is inequality, but I'm not able to get at it.
Justice, we
on the jurisprudence.
Yes, I'll return to it if I may. Once I've given it a bit more thought, but our position is that it's in relation to this group of people, their particular disadvantage, the inability to voice their own concerns, that if these similar steps were taken against other men, against other healthcare users, this would never have happened. It was only possible because this is a marginalized group and because they are disempowered. And that the stigma that Professor Grobler spoke about is very much in the midst of this mix of facts and events that have taken place. Of course,
you can come back to that in reply and so on. You've heard my
yes, Justice.
My concerns are legal.
No, I hear your concern.
Yes.
I hear your concern. On the right of access to quality healthcare services, I alluded to our argument earlier that the breach in respect of this right is in relation to Section 27.1 and the negative infringement of the right rather than Section 27.2. The evidence is clear. They were receiving a level of healthcare services and a quality of healthcare services. The enjoyment of that right was taken away from them.
And none of the internal or external qualifiers of Section 27, we've talked about that already, come into play. We haven't had a defense that says, I had no money, I was trying to provide progressive realization, or any of those defenses. I mean, none of that was raised. If anything, we were told the opposite.
That's right. We were told the opposite. And if anything, and as we know, the budget was there for the mental health care users when they were at life, Esidimeni. So there's no qualifier in relation to available resources and the like, the triad that's of qualifiers that are in Section 27.2 of the Constitution. Yes. And then the founding values, we refer to the founding values of the Constitution and the principles governing public administration, and I have to say, Justice, we cannot stress this enough. It's often disregarded because it's not part of Chapter 2, Section 195. Of course, the founding values are in Section 1. But it is not understood and appreciated, in my view, and was not appreciated in this entire process, nor in the way it was dealt with by officials in the hearing, that without those values and adherence to those values and the obligations in Section 195, one cannot give effect to the constitutional promise of a democratic society based on human dignity, equality, and freedom. And we set out the provisions in Section 1.
Yes, the intriguing part, in my view, of that argument is the link inevitably that ought to be made between Section 1, the rule of law requirement, and Section 195. Once you're obliged to uphold the rule of law, to act in accordance with the law, and 195 tells you what you ought to do. So there's that connection between that founding value and the obligations to be a good public servant, a good public official. It's founded not in just humble pie and goodness, it's founded in a constitutional provision, which is part of the supreme law.
That is so, and it's for that reason that Section 195 is as detailed as it is.
Indeed.
Our argument goes further than the connection between Section 195 and Section 1. It's also the connection between Section 195 and Chapter 2.
Yes.
And that the inability to rely on Section 195, and in fact, the refrain by the officials that they didn't know that none of the warnings reached them denudes Section 195 of any value and meaning. It means that Section 195 is central to the ability of members of the public to assert their rights. Without the proper compliance with Section 195, we have what we have here. But also what it means is that if members of the public wish to assert their rights, they must go to court. Because that's the only way, if you're lucky, that you will receive a response from government. And of course, that is not the Constitution, the type of democracy that the Constitution envisages. Justice, it's 2 o'clock.
Yes, just to wrap up that point, is ignorance ever a good response to a public duty. In other words, to a constitutional obligation to act in a particular way. Is knowledge a requirement?
No, our law has long, well, at least in the criminal context, dealt with that question of ignorance. In this matter, what we've heard, yes, is we didn't know.
You see, here's the point. Let me phrase it much more tightly and narrowly. If there's uncontested evidence of egregious breaches of constitutional protections perpetrated by an official wielding power or those who report to her or him, and all you hear is, "I did not know," is that an adequate answer, or does that diminish the consequences of constitutional breaches?
We submit that it's not an adequate answer. We've dealt with why, in fact, it's not an adequate answer. And in law, it's not an adequate answer because the duties that rest on the officials are there in the Constitution and they're there in the statute. When they take office and when they swear the oath to uphold the Constitution, as in the case of the Premier and the MECs, they are bound by it. It can't be a legitimate defense to say, "I don't know what the Constitution says about the way I must go about my job." In addition, we know from the law that, at the very least, we have a certain expectation of officials, but also that in this case, the harm was foreseen.
I did not know that the NGOs would not handle them properly. I did not know that they would be transferred in this particular manner. I did not know that they would die. I did not know that the plan would be implemented in this manner. I'm struggling with the place of that claim of ignorance within a legal context. Can one validly raise that as a defense? When you have a statutory obligation to make sure it happens.
If that were to be regarded as a legitimate defense, Justice, I'm not sure how any of the cases against the state could be litigated properly when it comes to claiming a violation of a statutory duty or a constitutional duty. It's not the subjective condition of the person who's standing before you and denying it. We're entitled to expect that officials, there's an objective duty that rests on the officials. And in this case, to say, I didn't know this or I didn't know that, is actually lies at the hands and at the feet of those officials. It's something they should have known, in fact.
Because it may very well be that the correct legal position is putative knowledge. In other words, is deeming the officials to know. I haven't worked that through properly, and that's why I'm engaging you on it. It is an objective establishment of egregious violation by that official and or those who serve under him here. The question that arises is, can they without more say, no liability arises because I did not know? On the one end, there would be state liability. On the other, there would be, of course, personal liability. And it may be that the answer I did not know served different purposes in relation to different categories. And I got the impression that I did not know was useful to try and avoid criminal, or they thought it was useful to try and avoid criminal liability. But I don't know whether you could ever raise it.
But not as a matter of
within
law, as a defense.
As a matter of law, within a delictual setting. I did not know might just demonstrate gross negligence, if anything, but not a defense, would it?
That is so. That is so. And that's consistent with our principles of the delictual claim that's at play here. Justice, I'm happy to return to that and to engage further on it.
Yes, your other colleagues, I'm also, obviously, you know how arguments go. I'm flagging these things also for the rest of your colleagues, and for the state, for all counsel, so that they can expect that I will engage that with them. And usually it's things that worry me as a matter of law, having the duty to make those decisions. This was very helpful, thank you. We resume at 3 o'clock, do we?
I believe so, Justice.
It's
now
yeah.
just after 2.
Yeah. Thank you. We are adjourned until 3 p.m.